State governors have launched a fresh bid to delay the implementation of the Supreme Court's judgment granting financial autonomy to local governments. The governors are reportedly mounting pressure on top federal officials to soften the implementation. Recall that the Supreme Court on July 11, 2024, delivered a landmark judgment affirming the financial autonomy of the 774 local government areas in Nigeria. The court ruled that it was illegal and unconstitutional for governors to manage and withhold local government funds. Following the judgment, the federal government instituted a 10-member inter-ministerial committee to implement the Supreme Court's ruling. However, sources close to the presidency reportedly revealed that governors are lobbying top officials to stall the implementation. Now, joining us on the news to discuss more on this is a legal practitioner, Gloria Ballason. She is the CEO of House of Justice. Bella, thank you so much for joining us. It's good to have you. Let's get started quickly. I mean, since the Supreme Court judgment on financial autonomy for local government, all 774 of them, I mean, how many state governors appeared not to be comfortable with the ruling and have been working to ensure, that the status quo remain? Now, we've seen the governors come out. They want to soften the implementation. What do you make of all of this?
Well, what it means is that we are running a polity where people assume that the Constitution is a list of suggestions and that they can pick and choose what part of the Constitution to obey. And if we go on this trajectory, it's going to lead to mass chaos. And people who have sworn to uphold the Constitution, particularly state governors, they have the primary mandate of ensuring that the Constitution is obeyed and that they are the chief persons who are leading the obedience of this Constitution. Section 7 of the 1999 Constitution provides for the existence of local governments. And that is a mandatory requirement for our democracy because we have 3 tiers of governance, the federal government, the state, and the local government. And the idea of having the local government stemmed from the 1976 reforms that wanted a situation where people can be close to government, to governance and government structures. And so the 3rd tier was created. And I think that it is for good that we allow that tier to exist so that we can see how government and the people can form a united front and that there can be a symbiosis of both leadership and followership in such a way that it tells on our democracy for good.
It's very, you rightfully put it there, cherry picking when it comes to what suit and not suit. But while the judiciary has played a major role in this landmark judgment, some high courts have also been used by politicians to make a mess of the same local government independency through injunctions. We've seen it here and there. So a case study is Rivers Council election coming up this weekend, where INEC was barred from releasing the voter register to Rivers State Independent Electoral Commission. Again, how do you interpret this when it comes to elections?
Well, the Supreme Court is a court of policy. And once the Supreme Court makes a pronouncement, it is not up to any other court, no matter how strongly they feel about any other matter, for them to go against the decision of the Supreme Court. So at this point, it will just be the right time for the National Judicial Council to move in and to be able to rein in this kind of judicial lawlessness that is happening with certain courts taking decisions that are outside the decision of the Supreme Court. But over and above that, I think one of the things that comes out quite clearly is the politicization of our courts. And we see that over and over again, how politicians will run from pillar to post, forum shopping for judgments that will suit their spleen and will look like the kind of things that they want to implement. And more than ever, it's important that in any democracy that the judiciary insulates itself from being politicized. Because you see, politicians come and go. But we don't have any country that exists for politicians different from the rest of Nigerians. And the judiciary will come at the end of the stick if it plays to the gallery to what politicians want, rather than stick to what the constitutional requirements are and whatever policy has been formulated through the judgments of the Supreme Court. So this is an opportunity to course-correct. And thankfully, we have heard the Chief Justice of Nigeria take a firm stand around the fact that courts will not be allowed to do what they want. We hope that this is an opportunity for the implementation of that pronouncement so that we can begin to have proper order in our polity.
And hopefully she does make that stand. She's made those statements. We only wait to see, and only time will tell if it will be politicized or if it can, exercise autonomy and be, free of any sort of leaning or inclinations. But I have to ask you, with this local government autonomy and now with the state governors looking for a way to soften the implementation, what's the way forward?
The way forward is to hold state governors responsible where they decide to not obey the laws and the decision of the Supreme Court. You see, we must understand that nobody has the right to take powers in their own hands. Not the president, not the executive, not the legislature, not the judiciary. We must all be slaves to the law to rule by it if we want order in our society. But you see, unfortunately, people assume that once they get to power, that they can dance around certain things, and which also raises the concern around Section 308 and the immunity clause, because the reason why they can even contemplate taking these actions is because they assume that actions will not be taken against them while they are in power. But this is why it's important that people who are leaders, particularly the president, the vice president, the governor, the deputy governor, and anybody at all, that their leadership should be predicated on the obedience to laws as a living example. And so if we have governors who are looking for how to circumvent this decision of the Supreme Court and undermine our democracy, then it's also a good time to also say that they cannot swear to uphold the Constitution and go through another route and desecrate the Constitution. What this means is that they're not worthy of their offices. And we need to shift our jurisprudence to that point where people who disobey the laws are not allowed to occupy offices that have been created by the law. Because again, this goes back to your choice of word around cherry picking. You cannot say that you want to occupy the office of the state governor, but assume that the office of the local government chairman should not exist. Because it is the same constitution that creates the office of the president, that also creates the office of the governor, that also creates the office of the chairman of the local government. And so we must not have this sense of anybody feeling that they are more superior than others and then they want to bamboozle their own way. In any case, what are the fears here? Right. For many of them, this is about revenue generation. But you see, if we allow these structures work, it will also push governments into a more creative way of raising revenue. Because governance is not just about money. Any person who occupies that office with the bid to serve, with the determination to serve, should not be concerned about money. They should be concerned about service to the people. Right. And what having a local government does is to take the service closer to the people. So anyone who wants to undermine this arrangement by the Constitution should be held liable.
Well, I must say thank you so much for coming on. We appreciate you for doing this with us, Gloria Ballason. She is the CEO of House of Justice, a legal practitioner who joined us on the news. Once again, thank you so much.